Hi, I'm Anna Denton-Jones of Refreshing Law Limited, and this is my first video of 2017. Happy New Year to everybody. In today's session, I'm going to be talking about a recent case of Dewhurst and CitySprint, which is the latest in a line of cases such as the Uber taxi scenario, dealing with the gig economy and employers who are engaging with people instead of as employees or as workers, as self-employed individuals, claiming that these individuals are in business on their own account and therefore don't acquire certain rights. In this particular case, the lady involved was claiming holiday pay, and she'd worked for CitySprint as a courier for a period of time. She'd worked every day, 4 days a week from 9:30 when she had to log into their system until she logged off again at around 6:30, and in between times she was sent from a central point jobs that were allocated to her that she had to fulfil, where she was instructed to do so with a smile and wearing their uniform. Now, when the courts have looked at this, previously the Supreme Court in a case called Autocleanse and Belcher has referred to not just looking at what the contract says, looking at the reality of the situation. In this case, the contractual terms that the lady was asked to sign up to made it very clear that she had no legal status, that she was self-employed. She had to tick to say that she confirmed she understood this, and she had to tick to say that she understood she could provide a substitute, but it would have to be from within the pool of approved other couriers that they would use, so essentially one of her colleagues. She had to tick and, if you like, consent to the fact that she knew she wasn't going to get holiday pay, sick pay or maternity pay. But the court in Autocleanse and Belcher instructed the tribunals and judges to look beyond that situation, look to the reality of the situation. And of course, the reality in this situation is this lady is not in self-employed circumstances. She's not like me. She doesn't go out and get business from lots of different people and have lots of different customers. She was working for this one organisation. And so the reality of it is she starts to look and smell very much like a worker. And indeed, that's what the judges have confirmed, that she should be regarded as a worker and was entitled to her holiday pay. Undoubtedly, CitySprint are going to find themselves inundated now with claims from every other courier they've ever employed, who will also be claiming holiday pay for the times that they have worked with them, along with lots of other rights like national minimum wage, perhaps. Now, hopefully you're not an unscrupulous employer, and you won't be worried about the fact that you might be exploiting lots of people. But I think what it does require us to do is to look more closely again at circumstances where we might have individuals that we do engage with who aren't our normal employees, or who aren't other workers that we might work with, but where the lines might start to get blurry. I'm not talking about, a situation where you, employ me to come in and do some training for you. Obviously, in those circumstances, I am genuinely self-employed and I'm just providing a service. But have you got anyone around the fringes who maybe starts to look a bit more like an employee or a worker, where trying to say this person is self-employed perhaps is not wise in the line of this direction of travel, and maybe we need to look at re-engaging with people in a slightly different way. If you've got any questions, please do come back to me. It's adenton@refreshinglawltd.co.uk.